Are you a real estate agent looking to break away from the ordinary and offer your clients something truly unique? Then you won't want to miss the South Shore Real Estate Summit, happening on May 7th, 2025 at Stellwagen Beer Company in Marshfield, Massachusetts. This isn't your typical real estate conference. At the South Shore Real Estate Summit, we're shaking things up and challenging the status quo. We're bringing together the brightest minds in the industry to teach you unconventional solutions that will give your clients the edge in today's competitive market. Whether you're mastering creative financing, exploring non-traditional transaction methods, or leveraging innovative marketing strategies, this summit is packed with actionable insights that you can implement immediately. Our expert speakers are seasoned professionals who have successfully navigated these uncharted waters, and they're ready to share their secrets with you. Plus, the early bird pricing ends in October 2024, so don't wait. Secure your spot today. The South Shore Real Estate Summit is on May 7th, 2025 at Stellwagen Beer Company in Marshfield, Massachusetts. For more information and registration details, go to www.southshoreresummit.com. Hello and welcome to South Shore Real Estate Podcast. My name is Carla Nee, and this week I am here with Karla Goodale from Heine Goodale Law. Thank you for being here with us, Karla.
Thank you for having me, Carla, because that's not going to get confusing.
I know. I know. It's great that we spell our names differently, though. It's on paper, it's easier.
Yeah.
So, Karla, tell us a little bit about yourself for people who have not met you.
Okay. So quickly, I am a reverse snowbird. I'm originally from Florida, born and raised, went to college and everything else like that, and moved up here in 2000 for a different career choice. But I pretty soon thereafter got into real estate. I was a real estate agent full-time, working with builders and flippers and developers, everything like that. And the financial crash happened, and decided that I really loved real estate, but wanted to get into the other side of it. I didn't know very many female real estate conveyancing attorneys. I had never encountered one in my passings. And so I decided, well, let's jump in the mix. And I went to law school up here, started my career at another firm, was partner there. About 3 years ago, opened my own firm with a couple people. And so I've been in the real estate world for 24 years, been an attorney for over a decade. So we're here, still in the real estate, great life of the greater Boston, New England area.
Awesome. And you're also an instructor for South Shore Realtors, correct?
I am. One of my great passions in life is teaching. So this is a little bit of an extension of that. I am a certified CE instructor for real estate agents, continuing ed, and I do teach classes and provide as much support as they want from me to the South Shore Realtors Association.
Yeah, you're very good at what you do.
Oh, you're very kind.
I'll give it to you. You're an excellent instructor. So you're here today to discuss a couple topics. One of them is what to do when somebody dies and you get that listing.
Yeah. For a certain population of us, we can say stop, drop, and roll, and you know what that means, like sort of thing. Stop everything. The two kind of like kisses of death in my industry is when someone says, it's been in my family forever. Okay, well, what that means is no one has looked at the title for years and years and years and years. We were looking at titles on a bunch of properties the other day. The original title in the family went back to 1867. It has not gone out of the family for valuable consideration, which means more than $1, more than $100, more than, deeds used to say, for loving consideration. So the longer it's been in the family, the more problems we can have. And specifically, it's been in the family, and everyone does, well, mom died and it went to dad, and dad died and it went to the 3 kids, and then we did this, or I was the only kid, so it went to me, and so I own the property, and now I want to sell it. You very well may own the property, but we need a little thing called probate to prove that you own the property, that there's no disinterested parties, there's no creditors, there's no unknown heirs. I mean, people have second families that they don't know about, or children potentially from another relationship. So a lot of times, and I have 3 cases right now, one of them starting back in February, where, someone went to a listing appointment, someone signed, listing agreement, went under agreement, got to me. On 2 of them, I was a purchaser, one of them I was a seller, for the attorney side. And we immediately had to be like, time out, stop game, no one's moving forward, no one's doing anything. The one from February is a little bit of a different situation, which I'll touch on later, but we're not looking to close until the week of November 11th. And this all came to fruition February 13th. So the first thing that you should do before you go on any listing appointment is start looking at the deed. Now, people will look in MLS, they'll start with quote unquote public record, which is a good jumping off point. You at least know who the owners were at some point. The problem with public record in like MLS or the city or town website is when a deed is conveyed for nominal consideration, it goes into a trust, it goes into an LLC, it goes, someone adds or subtracts a person from the deed for $1 because of a marriage or a divorce, or they want to do a license to sell. So I'm sorry, so sorry, not a license to sell, reserve a life estate, and they add their kids or anything. None of that is going to show on public record. So if you see Bob and Sue, and then you're like, okay, great, I need to find Bob and Sue. Or you just see Bob, but you didn't look at the deed that added Sue at one point, then you're only talking with Bob, you're having the listing agreement signed by Bob, everything, the offer's been signed by Bob. And then we, as the attorney, get and we look and we're like, where's Sue? Everyone's like, well, what do you mean, where's Sue? Or, oh no, I've literally been told she's off grid, she doesn't care. Or she moved out of the country, we don't know where she is anymore. And I was like, okay, that's great. We got to go find Sue. And we have actually had circumstances where private investigators have had to go find someone to sell a property. This especially happened after the financial crash, and everybody just like abandoned their houses. They were like, we're so underwater, we're just leaving. And then people were trying to short sale it to try to save something, sort of thing. So the first thing you want to do is you want to have the proper deed. So is it in a trust? If so, who's the trustee? Have we seen the trust? Is it an LLC? If so, who's the manager? Like look on the Secretary of the States. If someone has died, we need to know. There's a lot of different choose your own adventures when someone has passed away. First of all, how did the people who own the property hold tenancy? So there's only 3 ways to hold tenancy. We used to call it husband and wife, or like a married couple tenants by the entirety, which means that last person standing takes all. There's joint tenants with rights of survivorship. Again, last person standing takes all. Then there's tenants in common, or if no tenancy was listed, it defaults to tenancy in common, which means when someone dies, if a percentage interest ownership has not been established in a deed, the tenancy in common is the only one that you can have in unequal interest. So you could have 99%, 1%, 38%, 62%, anything like that. That person's estate needs to be probated. So we had one earlier this year where this is where it gets tricky. Mom and dad kept taking it in and out of different entities. And the last time that they conveyed it, there was no tenancy listed. So when mom passed away and it went to dad, dad thought, I own everything. We were married. Dad did not. Dad passed away, sole survivor, only child took it. So he thought, well, it went from mom to dad, dad to me. He passed away. His only living relative was an aunt. So she took it thinking that she had it. And then she passed away and it was her survivor who opened the probate for her, only to get to us and say, we have to go open 3 more probates. So we want to make sure that we know, one, who died, does it matter? Because if they were a married couple and it's recorded land, not registered land, or they were joint tenants with rights of survivorship, like husband and wife, or married people by tenants by the entirety, it doesn't matter. Someone passed away, great, you have the power to sell. If it's registered land, there's a little step. You have to get deed approval, but not too bad. It's not the registered land that you normally hear about that you're waiting months and months and months. But if the second person has passed away, then we're looking at, okay, one, did they have a will? Did the will have power of sale language? Again, the older the estate plan, the more problems we run into. I had someone who had to do their estate plan over again. It was originally done in the 80s. And it didn't have all sorts of like, all the stuff about HIPAA, and it didn't have power of sale and the will, and like, all these different things. Because like everything else, estate plans have trends. And a big one for us is when the Massachusetts Uniform Probate Code was adopted in 2012, that changes a lot. So I asked people, okay, who died? Did they have a will? Did the will have power of sale language? When did they die? Because was it pre-NUPC or post-NUPC? Was a personal representative ever appointed? And if so, how long ago? Because after a certain amount of time, certain things, like if there was power of sale language in a will, they may have extinguished, they may not matter anymore. So the questions that we're asking are like, are we going to need a license to sell? Now, very important, anyone who's listening, you absolutely cannot get a license to sell until a purchase and sale agreement has been signed. Part of the process of getting the license to sell is taking the purchase and sale agreement to the court and saying, here's the buyers, this is the price, these are the terms. Do you approve this? Are you saying, yep, this is a long arms transaction, it's not going to an immediate relative? Is it, somewhat fair market value, unless there's a reason that there's an exception that it's not? Because you have to remember, the person that's the personal representative has a fiduciary to all the beneficiaries. So rather than being like, oh, I just want to sell it to this one kid for $100,000 when it's worth $900,000, the court's approving this. So people will say, oh, we already have the license to sell or something like that. You don't. And specifically, the license to sell is incredibly specific. This is something that sometimes attorneys and title companies, we get a little bit at odds with each other, because the license to sell is incredibly specific. So if it says it's being sold to, Jane and Joe, and for $500,000, and then the appraisal comes in low, and it's now $490,000, well, technically that license to sell is not correct. You need to go back to the court and get a new one. Same if all of a sudden buyers start changing, being added, being subtracted. Like we put them both on the P&S only to find out it's a VA loan and they're not married, and the VA won't let the significant other, like things like that. So what the point of all this is that before you go down and sit at a listing appointment, you need to find out who are the players you actually need to be talking to. And if there's only one surviving person, can they start to collect those documents? Was there a will? Was there an estate plan? Maybe who's the attorney of that? Or was there a trust? Can you have the whole trust in front of me so that I can see who the trustees are? Did a trustee die? Was there a successor trustee? Or is there no successor trustee? We might have to go probate the court to assign a new trustee. So there's a lot of work, kind of like getting a house ready. You're staging and you're doing, outside landscaping, and you're maybe doing some fresh paint, and you're doing all these things. It's the same thing from the title aspect, that you really want to be preparing. And we were at the South Shore Realtors new agent orientation last week, and I had a bunch of people come up to my table and they were like, well, someone died, but they're not thinking about selling until March or April. I'm like, great, perfect. It is never too early to lift the lid on that title, because you might have something that's going to take 6 or 8 months to get cleared up, so that when you list that house and you accept that offer and someone goes, I want to close in, 21, 30, 45 days, you're ready. You're no problem. We already know it's not stop everything. So, I think that is the having the proper players in the conversation, and then properly setting expectations of timelines. So if you do need a license to sell, or if there are publications that need to be made, or any of these other things, you've talked to the right attorneys to find out, okay, we are going to list the property, but we need to tell everybody we're not closing for minimum 60 days, or something like that. Because in this market specifically, I have people who, the day their offer is accepted, they've locked a rate for 21 days. And the minute we say, well, we're not closing for 60 to 90 days, they're like, well, who's going to do something about my rate lock? And I'm like, nobody. Or they've already given notice to their landlord that they're moving out, or they've done this or that, which I appreciate. This market is moving incredibly fast. So everyone's like trying to get their ducks in a row. But I'd be interested to find a real estate conveyancing attorney who would say it's ever too early, with rare exception, it's ever too early to talk to the attorney. I always say, get me involved on the sales side or the buy side as early as possible. Start setting expectations. A big part of it is, people don't have to usually be here on the sales side. They're finding a notary, they're getting us stuff, but buyers do need to be here on the purchase side. So they think, I've applied for my loan, I've signed my offer and my P&S, I've done everything online. I didn't know I had to be here in person. And like I said, with the, we've had people that have had to fly back from foreign countries. Like if you're not part of the Hague Convention, like sometimes getting documents notarized outside the country can be extremely difficult. So I've had people who have had to fly back to the country literally to go to a notary and fly back out. So start thinking about those sorts of things. But you know, if you're a snowbird in Florida and you don't want to come back for your closing in April, no problem. We can get that covered for you.
Yeah, I've had to do that a couple times, stand in as the POA for some people. I know that the attorneys do it quite regularly. Now, what if how would you suggest an agent doing their due diligence find information on the trust if nobody really knows where to go and obtain that information on their trust
So yeah,
or even an LLC?
so the LLC is relatively easy. It's the Secretary of the State's office. You just go into the Secretaries of the State's office, you look at the LLC, and it will say who the approved signers are. So again, like I may own the LLC from an operating agreement standpoint, but it might be my sister who's my resident agent, and she's actually the one signing the documents, not me, because I am not listed as, depending on the entity type, president, secretary, vice president, treasurer, you know, like depending on who needs to sign something. The trust gets a little bit more difficult. They've really changed some of our trust docs as of late because these trusts are causing so many problems. So back in the day, it's been a while, but back in the day, you used to record the whole trust. So you saw it, you could read the entire trust, you knew how, like, there's two different types of, well, there's more than two different types of trust, but like there's trust that the trustees can act on their own accord. There's other that it has to be at the direction of the beneficiary. So then we have to go find the list of beneficiaries, which has usually never been recorded. So it's this whole thing that then, I'm not exactly sure when the trend really became popular, but that you just listed a trustee certificate. It basically says, I, Karla Goodale, am trustee of the, you know, Heine Goodale Law Family Trust. I have, you know, pursuant to the trust, it has not been, you know, changed or revoked. I have the right to act in the capacity in which I'm acting, and anyone can rely upon this document, blah, blah, blah. I get it notarized, I stick it online at the Registry of Deeds, and everyone can rely on me. Well, the problem becomes, what if I'm gone? So there's something online that says, I'm here. Okay. So the title companies are encouraging us now to say, Karla Goodale is the trustee and a successor trustee is X, so that we at least have one other person. The other thing is a lot of trusts expire after like 20 or 30 years. I think 20 is the most common, but don't hold me to that. I haven't looked in a while. So people will call me up and be like, this trust expired 10 years ago. What do we do now? Depending on how long it's been not in full power and effect sort of thing. If it's been a couple of years, we can usually do something with it. The longer it hasn't been, you know, so now we might have no trustees. So one, you're hoping that you can find the whole trust. You're hoping that somewhere mom, dad, aunt, uncle, sister, brother left an important, where the important documents are kept. And if nothing else, maybe there's just a page that says, you know, will and trust kept at the vault of XYZ, and you can like call up that firm. The other thing that we're running into is, and it happened to us yesterday, we're looking for some documents, and I looked up the notary's name at the BBO. Attorney's retired. There's no firm that still exists. There's no anything else like that. So we have no crumb trail to, you know, go find. So if we don't know who the trustees are, or we knew who a trustee was and that person's passed away, you might be in court asking for the court to appoint a trustee to be able to, you know, wrap things up. So it's not just that someone died. It can be an LLC, a corporation, a trust that you may still need court action to get you to be able to have the power of sale.
Yeah, I've actually been looking at a lot of probate documents lately, and I'm
Lucky
seeing
you.
things, yeah. I've been seeing things go back, you know, years.
Yeah.
Like it's still going on, still completely active. Years. It's kind of crazy. I mean, a majority of them are like a year long, about a year long, but I can't believe how far back some of these have gone.
Yeah, and the funniest thing, and I don't blame them, because if I wasn't in the industry that I was in, how many people have no idea how they own their property? I've had full-blown fights with broker owners of real estate agencies who have told me, no, no, that's not, no, this is how, and finally I send them the deed and they're like, oh, that's right, I forgot in 2003 we did that, sort of thing. It's a set it and forget it. You do something with your estate plan, you do something with your deed, you do something, sort of thing. The other really sad thing that I see a lot, and I have it's a trick question that I ask a lot of probate attorneys, but I know why they do it. I get why they don't do what I would like them to do. So I won't fault them for it, is how many times people go, no, 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 it's in a trust. It's in a trust. It's in, mom and dad did a trust. We did a trust. We did a trust. And I'm like, great. I see that you did a trust. Did you actually ever put the property into the trust? And what usually happens is, we go round and round, and then I either get their trust documents and there's a page in there that says you need to fund your trust. Put your bank accounts, your like whatever it is. Like sometimes you don't put retirement accounts, but it's like put your bank accounts, put this, and put your house into the trust. But it was either an option to do it, and the buyers or the owners were like, oh, it's an additional expense because there's an additional drafting expense, there's additional recording expense. Like, you got to do it. There's a trustee certificate that's got to be drafted. There's a deed that's got to be drafted. Both those have to be recorded, so there's an additional expense. And some people don't necessarily want their houses in the trust, or I know that because of like Florida Homestead Act and New Hampshire, because they like how their taxes are, like there's different things going on. So people have been like, wait, so we paid all this money, or mom and dad paid all this money to do an estate plan, and the house still has to go through probate, and the house is still going to be for capital gains. And I'm like, yes. And so I talk with a lot of probate attorneys, and I'm like, I get why you don't do it. And I also get how the end user doesn't understand the importance of it. And I will promise you that there's something that I did my estate plan quite a few years ago. I have still never put one account. And it's the account that should be in my trust. And every time literally it's sitting right here. Like it's the thing on the dining room table that you just keep looking over. And every day I'm like, as soon as it slows down, I just got to fill this out. I got to send it in. I got to but it's a process, like sort of thing, because not every bank will let you put certain things into trusts and, this, that, and another thing. And so I'm guilty. I'm the cobbler whose kids have no shoes. Sort of thing. So I'm totally guilty of it. But it's almost like one of those things that I wish that before I walked out of the office, they were like, no, you're paying me an extra hour and you're sitting here and you're doing it all, because my husband was like, what are we doing? And then when we wanted to go put things into trust, every time I was like, no, we both have to go together because it's going into the pour over trust. It's happening this, and trying to get the two of us coordinated on a Saturday before noon. And this, it took years. I think we did it last year, and we did our estate plan before COVID. Like we were horrible. We are the exact people that I say don't be. But it's hard. It's hard. There's a lot of steps that go into it.
It is hard to get that, that dedicated time together to actually sit down and do something business-like.
Yep.
We've been trying to get to the post office since they lifted the pandemic rules, just to get my kids' passports. We still haven't done it.
Yep.
I have all the paperwork. It's all ready to go.
Because you both have to be together. You both have to sign everything. Yeah. It's a, and everything takes precedent. You're like, oh, but I got to do this. Oh, but they have a game. Oh, I got a grocery shop. It's the same reason that people don't do estate plans. You talk to them. I'm like, the minute you have an asset or a kid, you need an estate plan. Like, I get it that you don't think you really have anything, but you do. And I talk to people a lot about estate plans, and I swear either people don't want to talk about death, which I really appreciate, but no one's gotten out alive yet. So it's happening, literally. We just don't know when. And that's the scariest thing. You don't know when. Then the other thing is that I know so many people who are like, well, my wife and I, or my husband and I, or, whatever, can't decide on who gets the kids, so we're just not doing it. And I'm like, but bless you, you realize you both have to go in order for this, But I heard something last night, and I've said it about estate plans, but, I heard someone say the other night, it's like, oh, but if you don't have a prenup, you do have a prenup. It's just the government decides what the prenup is. And that's what I always say about estate plans. Not all marriages, not all children are the same. And so, if you don't have a healthcare proxy, if you don't have powers of attorney and stuff like that, the state or the government gets to choose. And so if you absolutely did not want money or property or anything to go to someone, or you absolutely wanted one person to have it, more than their fair share, if you haven't put that into writing, then everyone's going to be treated equally by the intestate statute or, whatever else like that. So, or if you absolutely know that, your wedding ring or china or something was supposed to go to your great niece, because she always admired it, like, well, that's not who it's going to go to. So, I always tell people, I'm like, I don't know, for me, it's peace of mind, just knowing that, like, my husband and I had to sit there and I was like, I can't imagine pulling you off of tubes, and I can't imagine putting you in a, 3,000-degree oven. But you have sat here and told me this is exactly what you want. So now I know. And so now when I have to make that hard decision, I can say, well, my husband sat there and told me that's what he wanted. So for me, it's freeing more so than it is like, I don't want to talk about that.
Right. Yeah.
And now we're way off topic, but I love it.
Yeah. I could talk about that stuff forever. I've been through way too much of that myself.
I find it's the people who have to do it for a loved one are the people calling me up being like, okay, I got to get I'm not doing this to someone else.
Right.
That's usually what it is. And especially when it happens to someone who's relatively young and they're like, I just had no idea this could happen.
Right.
And I'm like, yeah, you never know.
Okay. So, so another thing that you wanted to talk about today was interfamily conveyances.
Yes, but I did forget to bring up one ancillary thing about someone died. It's not about someone dying. It's someone becoming incapacitated. Do you mind if I talk on that for 1 second?
Yes, I'll let you take the driver's seat.
So you talked about earlier that you were like power of attorney for someone. So there's a couple different types of powers of attorney out there. There's limited, there's durable, there's springing, which we don't usually use anymore. The number one thing that people need to realize is, like, once someone doesn't have capacity, the option of electing a power of attorney is gone. And so we get that a lot, that, again, it's Barbara calling me up saying, I want to sell my house. I heard you're wonderful. Can you represent me? And I say, yes, of course, Barbara. And I say, give me your address. And I'm looking up, and then I go, okay, so where's Henry? Oh, Henry. Yeah, Henry's in a dementia ward. Oh, okay. Do we have a power of attorney for him? No, but we're married. Yep. What are we going to have? We're going to have to go to the court. We're going to have to petition for a conservator. The conservator is going to have to be appointed. Like, Barbara doesn't have the power to do anything. So we need power of attorneys ahead of time. Also, people think because maybe they've had a power of attorney for a sale, they can have a power of attorney for a purchase. Powers of attorney for a purchase are very lender specific. The lender has to approve it. The lender needs to know why is a person who won't be there. Travel's never a good enough, like either a work trip or something like that. It's a lot of times said, nope, you just need to postpone closing. The other thing is who can be your power of attorney. Some lenders make it be like an immediate family member. Some people will let it be kind of anyone. I can't be a purchaser power of attorney if I'm your closing attorney. So it's important, and it's not something like the night before we can be like, oh, she just decided she wants power of attorney. It has to be approved by the lender and the title insurance company ahead of time. And then additionally, we need to let the lender know that's happening because we have 2 additional documents that need to be recorded. So not that it messes up anything with the closing disclosure and stuff, but it's a necessary note to them that we've got these 2 additional documents that need to be recorded. So powers of attorney, again, I'm not saying that they're off the table, and on the other thing with sales, very specific. Again, probate attorneys our worlds combined a lot, but we definitely have different rules that we live by, and we have to live by as real estate conveyancing attorneys a lot of times what the title companies are telling us. Fraudulent conveyancing of property is rampant, absolutely rampant. So people will call me up and go, yep, I have a power of attorney. I go, great, do you have the original? And if you only have one original, you may never get that back, becomes the problem. Depending if it's registered land or this, that, or another thing. And if we're not e-recording it for some reason, there's then going to be a stamp on it and everything else like that, which now banks may not take. So used to be you only created one power of attorney. I know that estate planning attorneys are starting to create more, but then keep them in safes or vaults or, anything else like that. And when I had one recently, she goes, no, I only have a photocopy. And my sister only has a photocopy. But if you look at the power of attorney, it says right there, photocopies can be treated as originals. And I said, that's all good and fine. But for real estate conveyancing, for the registry deeds and stuff like that, photocopies are not considered valid as, and she was very upset with me and was like, I'm going to find another attorney. I said, you're more than welcome to. but you're not going to get a different answer. And even if you get a different answer from me, the buyer's attorney is going to tell you no. And so I tried. I immediately was like, hey, we're going to sign in under power of attorney. Here's the power of attorney. And the guy wrote me back. I know him well. He goes, you're kidding, right? And I was like, I picked up the phone and he's like, I'm not accepting it. And I was like, I know, but I needed to try because my client really wanted me to. So that's something that, ends up, people think that they've done everything right because they've got the estate plan and this, that, and another thing. And then they don't have an original and we're back to, we have a problem. So powers of attorney are also, and I need to see what the powers are granted. I had one time that the powers are granted. It was an online one size fits all power of attorney, and there was not sufficient power of sale language in the power of attorney. So someone was like, no, I have this. And I was like, right. And listen, I'm ultimately not the one making the decision. I always send it to the title company. I'm always like, will you accept this? Because if they say yes, I have their blessing. And, if I can't get a yes, then it doesn't matter. Again, we're giving it away. We'll give it away however we want. But again, the fraudulent conveyancing is so rampant that powers of attorney are highly suspect and really, and honestly, the answer is, even if the power of attorney doesn't say we need a doctor's note or something like that, some people are like, nope, we need a doctor's note saying that, in fact, there's no capacity to be had, sort of thing.
Hey, it's Carla Nee, and I've got something big to share with you. Look, the market's doing its thing, and if you're like me, you're always looking for ways to stay ahead of the game, especially when things get a little shaky. That's why I'm stoked to be a part of something truly powerful, the 21-day recession-proof challenge with Alchemist Nation. I'm not talking about just another course that you sign up for and forget about. This is 21 days of straight-up actionable strategies to make sure your financial foundation is rock solid, no matter what the economy decides to do. And here's the best part. I'm going to be with you every step of the way. We're going to dig into the tactics that pros use to stay ahead, grow their wealth, and protect what they have built. Whether you're just dipping your toes into real estate or you've got a few deals under your belt, this challenge is going to take your game to the next level. And I should know, I have taken this course a couple times. Now let's sweeten the deal. When you jump onto this challenge with me, you're also getting a ticket to the Alchemist Nation Summit in Orlando, Florida, this October 18th through the 20th. I will be there. This isn't just any event. This is your chance to rub shoulders with some of the sharpest minds in business, learn directly from the best, and walk away with strategies that could change your life. So here's what you do. Head over to carlanee.com, CarlaNee.com, find the 21-day challenge, lock in your spot, and let's go to work. And hey, don't keep this to yourself. Share it with your friends, your family, or anyone who needs to hear this. Let's bring them along for the ride. I can't wait to see you inside the challenge and at the summit. Let's get recession-proof together and let's make moves that count. Stay focused, stay hungry, and remember, we're in this together. Let's crush it.
So now we can talk about intrafamily communities.
Well, now I need to put in my 2 cents. I think it's, the power of attorneys now are super important, especially for agents, because we're constantly getting those text messages saying, my boss wants to buy property. What's your WhatsApp number?
Mm-hmm.
I get all the time, I want to sell my land in Nantucket, but I'm overseas in England. And, some of these, and it was just on the news today, how AI seems so, it can make things sound so legitimate. I think the power of attorney, is really going to be something that we need to pay attention to.
Yeah, and honestly, we because we haven't fallen for it, but properties have come to us clearly fraudulent, and then eventually we get a bulletin that's like, notice this property has been brought to multiple attorneys, sort of thing. So the title companies have given us a protocol. Like, if you're like, have you or the agent ever met the person in person? If you haven't, have you had a Zoom call with them? Have you had it delivered a front and back of their driver's license? Have you sent a certified letter to their last known address to say, hey, your property is being sold? Is this, you know, your intent? Have you scoped them out online? Have you tried Facebook, LinkedIn, stuff like that? Like, is that driver's license matching? What, like, there's a whole protocol. Like, we as conveyancing attorneys are basically being tasked with, like, if you don't do everything that we're telling you and you fall prey to it, it's on you. Like, they're saying, you know, we wrote a title policy, but you didn't do it. And honestly, as attorneys, a little bit are like, when did we become like private investigators? Like, when did we have to add 27 steps to what we need to, like we get it, we are the last line of defense, but at what point does our responsibility, like, there was something that happened, I don't know if it was this year now or technically last year, and it was like, the probate court gave a license to sell. The probate court gave a license to sell. The person who had been appointed the PR was a bad actor who had doctored a death certificate. And so the question was, which attorney's fault was it to have this fraudulent conveyance happen? And, you know, the seller's attorney rightfully so was like, the probate court gave me a license to sell. I can't question the probate court. That's like me going to a divorce court and being like, I don't think you're legit. Like, at what point, you know, everybody's playing the hot potato, not my fault, not liable. But where does this stuff end? Like, I'm a private investigator now on Facebook and LinkedIn and trying to, you know, and was the death certificate legitimate? And a lot of them are out of state because people retire from Massachusetts and go someplace. So this person that had been fallen prey to fraudulent conveyance lived out in Washington State. He had no idea his property had been sold. The property had been sold, a house had been built on it, and then sold to a third party.
Oh,
and
my
that's
gosh.
when they ended up finding out. A neighbor contacted the attorney, the seller, was like, you built a beautiful house. And he's like, what are you talking about? And I know you've seen on the news, the ones in Hawaii, and it's like usually kind of the far flung, the Capes, that it's, you know, it's not like downtown, you know, Braintree, where it's like someone tore down a house and like raised it back up. It's usually more the vacation-y spots, the land, the Western Mass, the this, that, you know, that's really where it's. And if anyone's interested, I don't know if they still have it up, but the Essex South Registry of Deeds in Salem, they used to have a table. It was like I remember, I think it was a 6-foot table. And there were just stacks of paper on the ground and they were like, this is like 0.1% of the paperwork on the lawsuits of fraudulent conveyancing that's occurred. And it was like very impactful to look at and be like, wow, this is really happening out there. And this was a couple of years ago. So yeah.
That's interesting. I'll have
so really
to check
the agency to be like, when you get that call, we can't say it's not legitimate. People do move overseas. People are foreign owners. Like, that's like, it's not we don't have to, it's a tightrope that you're trying to be like, I believe that you're legitimate, and I also don't, you know, like, prove it to me. But a lot of the WhatsApp, like, I got that I'm on a rig in the Gulf of Mexico and can't this, that, and another thing. And I was like, okay. And I just kept being like, you know, when can we have an on-camera call? When can we? He's like, well, can you just get the PNS done and this, that, and another thing? And I was like, nope, I need to have an on-camera call. And it went on for like 2 weeks, and then he stopped emailing me.
Well, the ones that come in and they want to sell their property, I mean, they go into the deeds and take the names from the deeds. And they're like, this is my address, my name is this is my address. So, I mean, for the newer agents, it could really take them for a ride.
Yep. It's tough. Like, we've talked about, like, do we send the sheriff's office, almost like you do like with an eviction note, like, do you send the sheriff's office to try to determine? Because if you look on public records and the address of the person is the home address, well, it might get delivered or it might get forwarded, you know, you don't know. And a lot of it seems to be coming out of Canada too. That's a big one. I've seen a lot of the bad actors are in Canada. Giving Canada a bad name, my goodness. Okay, so now you want me to get into intrafamily conveyancing, correct?
If you wouldn't mind.
Sure. Okay. Tons of intrafamily conveyancing going on. So what does intrafamily conveyancing mean? Intra, in between, not an outside party. So one thing that I didn't touch on when we were talking about powers of attorney and someone's passed away is on the face of the deed, just remember, everybody, if there is a life estate, they'll be like, you know, Barbara and Joe grant to Tommy and Mike the property, but Barbara and Joe reserve a life estate. When Tommy and Mike go to sell, if Barbara or Joe are still alive, Barbara and Joe are also signing the deed. And if Barbara and Joe don't have capacity, we need powers of attorney for them. So that's a big one that people miss. So intrafamily conveyancing, sometimes I bring that up because sometimes that's what's happened is grandma and grandpa have left the house to mom and dad with one of them reserving a life estate. And now mom and dad are like, we have all this equity, you know, grandma and grandpa gave it to us for a song and a dance back in the day. And now we want to be kind enough, if my parents are listening, take heed. We want to be kind enough to just give you this house outright, or, you know, whatever else like that. Or sometimes they'll be like, we want $200,000 equity and then you can have the rest. So the really great thing about intrafamily conveyancing is that if you're taking out a loan, if the borrowers, the people, the ultimate owners are taking out a loan, anything that the person that's giving you the house is giving you can be used as your down payment. So you can very many times already have like that 20% down, which means you're not having PMI or private mortgage insurance. You know, you're getting the best interest rate that you can for the property type and, you know, your credit score and everything else like that. So that's what's really fantastic. So you might be inheriting, you know, let's just for easy numbers, $1 million house, but there might be, you know, it might be completely paid off, but mom and dad might say, hey, we want $250,000 because we want to go to Florida, buy a house outright, call it a day, you know, and they're like, okay, great. So they're just going to go get a loan for $250,000. That's it. Now, every intrafamily conveyance is a little bit different. So first of all, if there are mortgages on the property, those have to be paid off. If there are any sort of home equity lines of credit, this is something that surprises homeowners and then some agents, is the home equity line of credit is tied to the house. Even if you've taken the $100,000 out and put it in your account, it is tied to the house. So that has to be paid off. Additionally, if you've taken out any a loan assistance for windows, roof, furnace, boilers, or anything, everything has to be paid off on the house. For the most part, if there's a loan being taken. So if, you know, any lender out there, any bank, any correspondent lender, broker is giving a loan, they're going to want all the taxes paid off, back water and sewer, all of that sort of stuff. If mom and dad are just kind of giving it to you and we're just signing over a deed or, you know, something like that, then the level of scrutiny is a little bit different. So I have one right now, and unfortunately we have a title issue. We were supposed to close next week. And, you know, basically the big thing about the son wanted to get in there and start getting work done before the ground froze and everything. Cause it's really, it's a flip, you know, his mom has owned it for a really long time and the bones are good, but it just needs work. And so now that the title company or the title issue is here and she's going to Florida for the summer or the winter and, you know, everything else like that, we're trying to figure out like, what does this look like? So it's actually, you know, we could close if they wanted to because there are no mortgages coming in or anything. But what we're missing is, you know, mom refinanced back in early 2000s. And then when she refinanced again, that mortgage was never discharged of record. That's the attorney that has retired. We have no proof to show that she actually ever paid it off. So by statute, there's another 9 years. In 9 years, this is no longer a problem. It's gone. But in the meantime, you know, I talked to the son and I said, you're doing all this work. At what point are you going to get a loan? And he's like, oh, I'm probably in like 3 years. And I was like, well, this is going to be a title issue for you. You won't be able to get a loan until this is cleared off. So we're postponing closing and, you know, doing something. Yes, you had a question.
Oh, I just wanted to, I was wondering if you could clarify. So when you say everything's due on sale, like the monies are due on sale, yeah. When you're taking a loan, is that when, say, the parents take a loan to buy their house, their next house, or a loan for
so when the deed gets recorded from mom and dad to son and daughter-in-law? Okay. That is when all of any financial obligations that are tied to the house. So liens of any sort. So if there's credit card liens, if there's car liens, if there's tax liens, water sewer liens, mortgage liens, UCC filings, like if there's solar panels, those can be solar panels and stuff can be transferred, but you know, we need to make sure we treat it like exactly from a title standpoint, like it's a regular sale. But okay. So certain things like there are different rules. It is very specific, but there are in some cases, Title V doesn't need to be completed at the time of sale. If there's a no lender, usually involved, that would require it, or we can show that they get a pass for 2 years. It is very specific. It is not like grandmother to son-in-law. It has to be like immediate. It's not great niece. The statute
Okay.
says exactly who it can go between. So that's kind of sometimes nice, because maybe what, son and daughter-in-law do is they get the house from mom and dad, and then they go take out a loan to put in the new septic or to put on the roof, or, something like that. The scrutiny, is really about more what mom or dad or, whomever giving the house, what do they want out of it? And what do the kids want? Sometimes kids will call me up and they're like, we're paying for all legal fees, like transfer taxes, recording fees, like we're going to pay for everything out of our pocket because mom and dad are, giving us the house. Or, we also don't have, there's usually not agents involved. There's usually, kids are going to take it as is. They're not like, mom, you got to get all the paint out of the basement, or, so there's a lot of relaxed kind of scrutiny behind these deals because of the intrafamily conveyance. But I do always encourage people, like, listen, you each should have an attorney. Like, a lot of times they say, no, we're not going to have, a second attorney, and then we have to give all the proper disclosures and everything else like that. But I never hold people back. I'm like, listen, I'm trying to make it as even as possible as I can for you guys, but I clearly, am usually representing one party, sort of thing. But the interfamily conveyances, it's a great way. Now, we have to think that sometimes about interfamily conveyances, and I'm not going to get into it. I'm not an accountant. I'm not a CPA. I'm not a bookkeeper or anything else like that. But, when you're transferring property for like zero money, the kids just inherited like a zero tax basis. So when they go to sell, they got it for zero. So when they go and sell it for 1.5, it's a complete taxable event. It's the same when, mom and dad try to start giving their kids a deed, and, mom and dad had a step up basis from, what they bought it for and things like that. So, and sometimes, there's quote unquote, ghost taxes because mom and dad just gave away $1 million. And like the IRS is like, I want my piece of that. But there's different, I know, like files and forms and like the lifetime gifts. And so, your CPA or bookkeeper can help walk you through that. But there are little things to think about when you're giving away hundreds of thousands of dollars of, we all know Uncle Sam wants his piece of it. So how do you structure it correctly? It's not a big deal. It's just forms that you fill out at tax time and everything else like that. But again, I tell people, the people who are giving it to the kids, we should probably talk about that. And you should talk to your CPA or your financial advisor about what that looks like. And what does it look like? Because, like with the one that I have, sometimes what it is, and this is where like I have no idea between your financial planner and your CPA, sometimes it's like it'll be seller financing. Mom and dad are like, okay, we're expecting to be repaid, but we want it in small increments. Like maybe we only want $50,000 a year for 10 years, because between what we're getting in investments and Social Security and everything else like that, we can't get more than X money. So we don't want to get a whole, so sometimes what we'll do is a private, note and mortgage that says there's no interest tied to it. Or, or it's a really low interest rate, or the first 5 years, there's no interest, and then it kicks into a 2%. Like we can get creative with notes and mortgages and stuff like that. Whenever anyone tells me like, do we really need this? Like, he's just going to pay me, or she's just going to pay me. I'm like, you're asking an attorney. If everyone's going to be on the up and up, it doesn't hurt to have a document that says it. The problem is when everyone's going to be on the up and up and you don't have a document, and then when you stopped being on the up and up. And a lot of times what ends up happening is, I tell people, again, when you're putting your kids on the deeds and stuff like that, because you think you want to make it easy. You're like, I'm just going to add my kid to the deed because if anything happens to me, then he'll get it. But you have to remember that once the kid's on the deed, that property is partially theirs. And so therefore, if there's ever a divorce situation or anything else like that, that's considered a marital asset. So a lot of times what we see is like people come to me and they're all heartbroken and like, they can't do this. And I was like, yeah, but mom or dad did this. Like it probably, even trusts, you can find the actuarial of like what it's worth or anything. They can even long arm it into a trust, but like there's other ways that we could have structured it. And yeah, it probably would have cost money and, everything else like that. But it really is sad when I see parents, what they've done, or grandparents, and they really thought they were doing the right thing, and they've either made a financial tax mess, or they've made some sort of mess about it, that it's not an easy fix. And you know that if you talked to them at the time and they said, well, this is what I think I'm doing, and you're like, I know you think you're doing that, but you're doing something completely different. So that's something that, you know, you want to think about as well, about maybe mom and dad do want an income stream, but they don't want it all at once, or they know that like the kids can't afford it right now. They're getting on their feet. So maybe this payment starts, it's not so much a balloon payment, but maybe it starts in 5 years and then goes for 5 years when they know they're going to be making more money, or, you know, like something like that. So there's a lot of different ways for intrafamily conveyances that you can get creative.
Yeah, and that's a really great way for, you know, this generation, or the, you know, the generation that's coming into the workforce now, who are living at home with their parents because the market is just too much for them. They can't afford their home. You know, the seller, you mentioned seller financing. That's a great way for them to obtain an asset and then later get a mortgage later on as well.
Oh, and there's so many creative things. I mean, for the parents that, you know, have the means, you know, when I talk with financial planners, are like, okay, so mom and dad are going to do this with their finances so that the loan isn't being taken out, and it's a short-term loan, because then this is going to, you know, or someone's borrowing against a 401k or this, and, you know, and it's not me. I can absolutely promise you it's not me when it comes to the finances. I'm not bad at math, but like the minute they start talking about charts and graphs and this and that,
Right.
I'm like, okay, I'm done. I chose my lane. That's not it.
Yeah.
But, you know, they'll really say like, oh, you know, a financial planner I know said to me not too long ago, I thought it was so great. When something big happens in your life, regardless of what it is, have you talked to your financial planner? Birth, death, accident, sickness, like you know, divorce, like good things, bad things, both sides, like, because usually what ends up happening is by the time they found out about it, it's kind of like me being like, oh my God, mom or grandma, what did you do? The financial planner is like, wait, why did you do that? Like, do you know that you went and sold all this stuff? Do you know what that tax implication is going to be? And we could have done this or that. And so it seems weird in the moment to be like, I'm going to call my financial planner, but they really are a safety net. And, you know, I look at how hard people, especially the older generations, they have like worked and scrapped and done all these things to like build this legacy for their kids and grandkids. And then when it gets just you taken out at the knees because they didn't think about that, you know, one thing. And that's, I think it's such an interesting generational like shift. Not that our generation or younger generations aren't thinking about their kids, but this older generation, I know my dad always says, my parents are in their 80s, and he's always like, well, I mean, like, we can't live too long. There's not going to be anything left for you girls. And I'm like, Dad, I don't, like, you want the extra banana or the extra dessert, or you want the extra beer or something, like, how, like, you've given us so much, you know, like, sort of thing, that like, don't be thinking about like, what are you leaving to us? But it is very much a generational thing that they scrimped and they did, and they saved and they did all these things because they're so proud to be able to give the houses or the businesses or the money or, you know, whatever else like that. And, you know, it's definitely for the people who are going to be the beneficiaries of that. It's really quite amazing. And like you were saying, you know, a lot of people are living at home and stuff. That's something that we see. It's sad that we see it a lot. And it kind of goes back to that estate planning that no one wants to talk about it. There's usually, you know, someone calls me up and it's either the recipient or the donor. And I get from one side or the other. I quit my job and I've been taking care of, you know, mom, dad, grandma, you know, whomever, and they're giving me the house because I basically live there and like don't have a salary. But I'm worried that my siblings or cousins or whatever are going to challenge it eventually, that they're going to think that I like coerced him or her into doing it. So same, grandma, grandpa, aunt, uncle, whatever, like someone has really taken care of me. They're always driving me. Like I want to give them the house. Like, but I don't want anyone to know about it. So can you help me create this? And I was like, okay, so you're plotting World War III. Like, I get it now. You don't want to start World War III now, but it's like, you know, the minute everybody finds out that James got the house.
But it's not their problem anymore because they're not there.
It's not. You're absolutely right. But then it's like, this is where all the litigation and the challenging of the wills and, you know, and I always say the longer ago it happened, the better off, because the chance that they have competency and everything, it's right like near the end when it happens that it really concerns me, you know, like sort of thing. And then, you know, we usually bring in a crew of people. We don't just have the two witnesses. We have more than that in the room. For when someone's signing over the deed, you know, we're asking all the competency questions, you know, all these different things to make sure that if we ever get challenged, like, are you sure? I can be like, listen, there was a room of people. Like I've almost gotten to the point paranoia that I want to like start recording it, but then I'm like, how am I saving it and everything? But really
Right.
being like making sure so that if we get drug into court and get challenged about when someone, signed over the deed, we know that it was, their free act and deed and they were competent to do so and, everything else like that. And that there was no coercion. We don't usually let the person be there. Even if they drove them there, we like have them in a different room, the person that's benefiting from it, because we don't want to feel like there was any sort of like duress or coercion or anything going on in the room. So, and then sometimes I'm like, I don't want to be the notary for that. Can someone else do it?
Right. Yeah. Yeah, but I think that's great standard operating procedure. So then that way you can say this is how we do it every single time. It's not just, how we feel at the time too. So
Well,
that's
it's
good.
funny because I always send the two witnesses in first before I go in, just to kind of listen to the conversation, like to see if there's anything that should be cluing me in beforehand, sort of thing.
Mhm.
I mean, sometimes it's not bad. I've either known the person or I've had multiple phone conversations and I totally get what's going on and I don't have any question of it. But there are other times that you're like, oh, or the people who are like, dad's really great before a certain time and then he gets sundowners, and I'm like, awesome. Like fantastic. Can we not have him here during that time? Sort of thing. Could we have a doctor's note? Could we have
Yeah,
something?
yeah,
Getting old sucks. That's the
gets
thing. I mean,
that
it's
gets crazy.
wonderful. Every day on the earth is wonderful, but wow, it's not for wimps.
Right. Yeah. Wow. Yeah. So, well, I want to thank you for being here today.
Anything else you want to talk about?
No, this has all been pretty great.
Okay.
So,
Fantastic.
all
Well,
right.
thank you
So,
so much for the opportunity, Carla. This was really fun. I always love helping anyone out that I can to, do their job a little bit better. I'm all about elevating the real estate industry. We don't sit on the beach and eat bonbons and collect big checks. We do the hard work. And I want everyone out there to know that with all the changes in the real estate industry, the agents are still incredibly important. The attorneys are incredibly important. The title companies are incredibly important. I know that our world is going in somewhat in a different manner, but, it's never lost on me that where you live and where you put your head at night is one of the most important things that you do. I might not remember what car you were driving at 25, but I can guarantee you remember where you were laying your head at night. And that's what's, where I feel that I'm not saving lives out here, but the real estate industry really impacts, our community. And so I love what I do and I love the other people who love what they do.
yeah. Well, thank you so much, Carla. And for those of you who are listening and want to get in touch with Carla, I will put her contact information in the show notes. So thank you so much and have a great day, everyone.
Thank you, everybody.
Are you a
Before we
real
wrap
estate
up,
agent
one
looking to
final
break away
reminder,
from the
don't miss
ordinary
the
and
South Shore
offer
Real
your
Estate
clients
Summit
something
on
truly
May 7th,
unique?
2025.
Then you won't want to
It's your
miss the
chance to
South
connect
Shore
with
Real
top
Estate
agents,
Summit.
learn unconventional
Then you
strategies,
won't want to
and grow
miss
your
the
business.
South Shore Real
Visit
Estate Summit happening on May 7th, 2025 at Stella and Beer Company in Mar